The 2019 amended Rules of Civil Procedure consolidated the pretrial phase into a single choke point that dictates the life or death of a civil case. Before any witness testimony begins, Rule 18 provides the court with the authority to validate, neutralize, or permanently dismiss claims on procedural grounds. Under these updated rules, the pretrial mandates function as a series of rigid tripwires, where any failure to comply results in the automatic loss of evidence or the termination of the action. Navigating this phase requires a forensic audit of Sections 1 through 10. We will examine the core principles, the general rules, and the specific pitfalls that consistently appear in the bar examinations. Successful litigation now rests on the understanding that the pretrial phase dictates every boundary of the subsequent trial. The Rule 18 timeline begins exactly when the last responsive pleading, the answer or the reply, is served and filed. This filing triggers an absolute duty for the branch clerk of court to issue a notice of pretrial within 5 calendar days. The court must then schedule the actual conference to take place no later than 60 calendar days from that same filing date. On the bar, examinees often confuse these two distinct deadlines. The 5-day rule governs the issuance of the notice, while the 60-day rule governs the scheduling of the event itself. Section 1 creates mandatory procedural momentum, removing the case's pacing from the parties and placing it under the direct control of the court. While pretrial aims for amicable settlement and the simplification of issues, its primary function is the identification and limitation of the evidence that will be allowed at trial. Section 2 enforces an absolute rule of reservation. Any evidence not marked or specifically reserved during the pretrial conference is barred from presentation. Reserving testimonial evidence requires specific details: the name, the position, and the nature of the testimony for every proposed witness. For documentary or object evidence, the reservation must include a particular and detailed description of the item to be presented. In practice, this allows a litigator to strike any surprise evidence an opponent tries to introduce at trial by citing the lack of reservation in the pretrial record. Section 2 creates an evidentiary lockdown. Documents or testimonies omitted from this matrix are legally excluded from the court's consideration. The pretrial notice under Section 3 locks in 3 specific dates: the pretrial conference, court-annexed mediation, and judicial dispute resolution. Section 4 mandates the appearance of both parties and their counsel. The court only excuses absences for acts of God, force majeure, or duly substantiated physical inability. If a party cannot attend, they must provide a representative with a special power of attorney that specifically authorizes entering into amicable settlements and stipulations of fact. Section 5 establishes the consequences of non-appearance. If the plaintiff and their counsel are absent without valid cause, the court dismisses the action with prejudice. If the defendant is absent, the court authorizes the plaintiff to present evidence ex parte within 10 calendar days, leading to a prompt judgment. For the bar, remember that a dismissal with prejudice means the claim is final. The plaintiff cannot refile the case. Sections 3, 4, and 5 establish a rigid attendance mandate, where a single unexcused absence can terminate the litigation. The pretrial brief is a substantive, mandatory prerequisite to the conference. Under Section 6, parties must file and serve this brief at least 3 calendar days before the date of the pretrial. A common examiner's trick involves a lawyer attempting to file the brief on the day of the conference. Under the rules, this is a late filing that triggers an immediate default. The penalty for failing to file the brief on time is identical to the penalty for failing to appear at the conference itself. Completing this filing 3 days in advance is the only method to ensure participation in the conference. Within 10 calendar days after the conference, the court issues the pretrial order. This document serves as the blueprint for the entire trial. This order permanently locks in the admitted facts, defines the specific triable issues, and sets the schedule for a continuous trial. The order enforces the 1-day examination and most important witness rules, preventing the use of trial delays. The pretrial order controls all subsequent proceedings. Once the trial begins and a witness has testified, the order can no longer be amended to include new issues or evidence. The finality of this document means that any legal theory or evidence omitted during pretrial is effectively waived. Sections 8 and 9 require cases with genuine issues to exhaust alternative dispute resolution through court-annexed mediation and judicial dispute resolution. Participation in these ADR stages is a structural requirement of the pretrial phase, not an alternative to it. If the pretrial conference reveals that there are no actual facts in dispute, the court utilizes Section 10, Judgment After Pretrial. When the defendant's answer fails to tender an issue, or when no controverted facts exist, the court can bypass the trial entirely. The judge may act motu proprio, on their own initiative, to submit the case for judgment, with a decision due within 90 calendar days. Section 10 allows the court to render a final decision immediately for cases that lack a genuine basis for trial. Rule 18 establishes the fixed architecture for the entire trial. Complying with this filter is the prerequisite for reaching the subsequent 90-day blocks of evidence presentation and final resolution. Mastering these procedures requires strict adherence to the rule of threes, the execution of precise SPAs, and the formal reservation of every evidentiary detail. For bar examinees and litigators alike, failure to navigate Rule 18 results in the loss of the trial before the first witness is ever called.